what James Clapper said under oath, and what Snowden released 3 months later. March 12, 2013. Washington, D.C. The Senate Select Committee on Intelligence was holding an open hearing. Most of its work happens behind closed doors. Classified briefings, closed sessions, conversations that never appear in any public transcript. But several times a year, the committee holds open hearings, sessions where cameras are present, where the public record is built, where the people whose work is normally invisible to the public sit across from senators and answer questions on the record. Ron Wyden had been on that committee for years. He understood the architecture of intelligence oversight, what senators could say publicly, what they knew privately, and the precise, uncomfortable space between those two things. He had spent years receiving classified briefings that detailed programs and capabilities the American public had no knowledge of. He had spent years trying to find a way to alert the public to what he knew without violating his own security clearance. On March 12, 2013, he asked one question. It was a question he had submitted to James Clapper's office the day before. In writing, formally, giving the Director of National Intelligence a full 24 hours to prepare a response, review it with counsel, and decide exactly how to answer it in an open setting. Wyden asked, "Does the NSA collect any type of data at all on millions or hundreds of millions of Americans?" Clapper paused. Then he said, "No, sir." Wyden asked again, "It does not." Clapper added, "Not wittingly. There are cases where they could inadvertently perhaps collect, but not wittingly." The exchange lasted less than 60 seconds. At the time, it attracted minimal public attention. The hearing covered many topics. The committee moved on. The transcript was published. The session concluded. Most of the people who had been in that room moved on to their next obligations, and the exchange between Wyden and Clapper became a footnote in a routine oversight session. Then, 83 days later, Edward Snowden made a phone call to a journalist in Hong Kong. The documents Snowden had brought with him, thousands of classified files from deep inside the National Security Agency, began appearing on the front pages of the Washington Post and The Guardian on June 5 and 6, 2013. What they revealed raised significant questions about the answer Clapper had given on March 12. The NSA, the documents showed, had been operating a program under Section 215 of the Patriot Act that collected metadata from the phone records of millions of Americans. The program had been authorized by the Foreign Intelligence Surveillance Court. It had been ongoing, and it involved exactly the kind of data Wyden had asked about. Wyden had known about the program. He had known about it because he was on the Intelligence Committee and had been briefed on it. He had asked the question specifically because he wanted the answer to be part of the public record, because he believed the American public was entitled to know whether the government was collecting data on them at scale. In a letter to Senate Intelligence Committee Chairwoman Dianne Feinstein dated July 26, 2013, 6 weeks after the Snowden documents began publishing, Clapper wrote that his answer to Wyden's question had been clearly erroneous. He said he had simply not thought of Section 215 of the Patriot Act when he answered. He apologized. He said his staff had acknowledged the error to Wyden's staff soon after the hearing. He said he could now openly correct it because the existence of the metadata program had been declassified. In a separate interview, Clapper described his answer as the least untruthful response he could give in an open setting. He said he had been thinking about a different surveillance program and had failed to consider the domestic metadata collection when he answered. Wyden described it differently. He said he had given Clapper the question in advance specifically to allow for a considered response. He had given him a day to prepare. He had given him a chance to amend his answer after the hearing had ended. He said Clapper had not taken either opportunity. In a January 2014 interview, Snowden said that Clapper's congressional testimony had been one of the factors that had influenced his decision to come forward. He said seeing a senior official provide an answer to Congress that the classified record did not reflect, and seeing no immediate consequence follow, had been part of what convinced him that internal channels would not address what he had witnessed. He quoted Clapper's answer directly when he explained his reasoning. The legal questions that followed the revelations drew significant attention. Under federal law, making a materially false statement to Congress is a felony. Several senators called on the Department of Justice to examine whether Clapper's testimony met that threshold. A 5-year statute of limitations applied, meaning any proceedings would have needed to begin by March 12, 2018. The Department of Justice did not bring charges. The statute of limitations passed. Clapper left government in January 2017. What the public record now contains is this: a specific question, submitted in writing 24 hours before it was asked. A specific answer, given in open session on camera. A classified program that the answer did not accurately reflect, as Clapper himself later acknowledged. A letter of acknowledgment describing his response as clearly erroneous. And a former NSA contractor who cited that answer as one of the reasons he concluded the public needed to know what he knew. Wyden had asked a yes or no question. The answer was no. 83 days later, the documents that arrived from Hong Kong told a different story. The hearing transcript is in the permanent public record of the Senate Intelligence Committee. Clapper's letter of acknowledgement is in the public record. The Snowden documents, the portions that have been declassified and published, are in the public record. And the 60 seconds of exchange between a senator who already knew the answer and the director of national intelligence who had been given 24 hours to prepare his response. Those 60 seconds remain one of the most documented and most discussed open session exchanges in the history of American intelligence oversight. Because the question was precise. The answer was on the record. And 83 days later, the world found out what the record should have reflected.